Uju, welcome everyone. So I'm talking to both the room and Zoom. So sorry, I'm not going to be looking directly all the time right at the room. My name is Laura Newton, and I am the Family Services Program Director at the Minneapolis American Indian Center. I'm also Ojibwe, and I've been working in the area of children, Indian child welfare and family services for over 20 years. I am excited about this evening because I have had the opportunity to work both for an in-state tribe as well as for tribes from outside the state of Minnesota. And we get tons of questions all the time about what the tribe's role is in child protection cases and what does the tribe do. So I'm excited for all the folks that are here tonight to get to share with you. I want to go over just a couple of things. One is that the event tonight is hosted by our Family Preservation Subcommittee from the Metro Urban Indian Director. So if you hear of MUID, we're a subgroup of that, and we focus on family and children's services. And so we're hosting this for families today. If you are on Zoom, if you can make sure that you're muted. And also if you can type in the chat, you can put your information in there if you want to share with other folks on the Zoom. For those of you not on Zoom, feel free to network. We had some dinner here tonight, which is lovely. So they've had some time to do that. For the folks that are here in person, if you'll please write down questions on the cards on your table. And then on Zoom, if you will put those in the Q&A section. Just to let you know, we can't answer anything really case specific, but we will try to answer your questions generally, and we will always connect you up with someone to help you if you have a very specific situation that you need to discuss afterwards. But we want to respect your privacy and make sure that you have confidentiality. We also have some wonderful people here with us. We have Charlene De Castro, her son Opie Day, and Desiree Denemy, who are going to start us with an opening prayer and song. So I'm going to hand it over to them. Thank you.
Oh, I love that camera catches my good side. Bonjour, and the way my done it. Meja keep na si keep playing indigenous cause. Objection to them. I see the community. Hello, all my friends and all my relatives, and best of all of the people that are working together to make a better life for our American Indian children and for our families. I greet you with a warm heart and a hearty handshake, and I say, welcome to this MUID meeting and this Zoom meeting to try to figure out what we can do better. And I've been asked to offer a prayer, and I'm going to offer this prayer. Normally we say it in our original language, mine with the Ojibwe Mille. And I'm glad to say that I've been studying full time for just about a year and a half now. I actually know how to say a little bit, and that's encouraging for even someone of my age to learn. But it's making a better life for all of us, and hopefully, as we continue to delve into our culture and our way for being and our reason for being, we'll all find also greater pathways. So I want to say to the Creator, I want to say, thank you for allowing all of us to be here. It's no secret, or it's no coincidence that we're all here at this time to try to put our minds together and try to figure out through visiting and listening and through respectful learning how we can make a better place and make a better way. Leave some better tracks for those that are going to follow us. We want to say that we offer gratitude for all of us being here. We also offer and acknowledge our existence for where we sit, for where we are, for the plants that are with us and the animals that are with us, all of the ancestors that came and went before us, and the ones that are still coming down the pipeline and have yet to reap the benefits of what we're going to do here tonight. So I offer that prayer, and I say that to the Creator, that we earnestly thank you, and we are grateful to be able to be here in the existence of each other. I was going to offer a prayer song, but then I've got the news that my children are back to the cities, and they do a much better job of singing a prayer song than I could ever do. So I'm going to ask them to stand up at this time. This will be the Midnight Express Jump, specifically Opie Day and Desiree.
Bonjour. And Andrea money do. John Quad Indigenous cause, Opie David do, Minneapolis and Digo. Olasisi and Big Game, Sagai and Nigga. Hello, friends and relatives. I just want to say thank you for allowing us to share a little bit with you guys tonight. My mother for asking us to be here, and all of my beautiful companion. Introduce yourself.
Desiree Denemy, Nasigasun, Papixies, Otsinia. Hello, my name is Desiree Denemy, and I'm from Papixies Cree Nation in southern Saskatchewan, Canada. And I'm happy to be joining you all and here to, and everybody at home to sing today.
Thank you.
Miigwech, Opie, and Desiree, and Charlene, thank you so much for being here. All right, so we're going to get started with our overview by the speakers. I'm going to start with Teresa Day, who is here from Red Lake. I'll let her further introduce herself. And then if you could just, I think maybe let's just have everybody introduce themselves first. So, you can slide it down.
Okay. Good evening, everyone. My name is Ben Lundquist, and I'm a Deputy Solicitor General with the Mille Band of Ojibwe.
Hey, bonjour, everyone. My name is Teresa Day, and I'm the Program Manager at Red Lake Indian Child Welfare Office. And our agency is part of Greater Red Lake Family and Children's Services, which is now called Opimentwagajan and Wimagani Nadag, uplifting all our relatives. You gotta say it now. I'm just kidding.
Bonjour, Martin Durin Indian cars, Makwa and Durim, Mesquagami, with Zagaigan in Dunjaba. My name is Shayna Clark. I am the parent from Red Lake who is speaking on behalf of my experience tonight.
Good evening. My name is Elise LaGarde. I am one of the tribal liaisons with the Minneapolis American Indian Center. Thank you.
Okay, so what we're going to do this evening is just have a brief overview from our panel here tonight. If you do have questions, maybe just hang on to them for just a minute or write it down if you can. We are going to have time to get to questions, but I want them to get through a little bit of information first, just to kind of give you a little bit of background. So we'll start with Teresa. And if you guys can't hear us in the room here, let us know or raise your hand. And it's a little different to do hybrid.
Yeah, I have to say though, I appreciate that the cart thing is happening, because before the camera was like right here, and that's just not a good look for anyone. So I was like, no, thank you. Okay, so this is such a huge topic, right? There's so much we could talk about. So I'm really grateful that we have such a cool panel here to get to some of these things. So I'll do my best to try to cover the pieces that have been entrusted to me. But I think just starting with tribal involvement, right? When do tribes become involved in a case? So the law is that tribes must be noticed, right, of any services that are involving an Indian child. So that could be voluntary services, voluntary placements for children's mental health, or voluntary foster care placements, obviously CHIPS cases, and any family assessment or family investigation. So the Indian Child Welfare Act and the Minnesota Indian Family Preservation Act mandates that there is a certain time in which that county, and remember the county is an agent of the state. This is a state-run, county-administered child welfare, or child welfare in Minnesota, right, is state-run, county-administered. So it's every county has their own child welfare way of doing things, but ICWA and MIFA lay out how notice must be given and when. So that's how tribes become involved. That could be truancy, like I said, pre-court involvement. And a lot of the times when tribes become involved is really tied to tribal capacity, right? So I think if you talk to any tribal worker, any tribal family, right, we'd want to be involved from day one. That's the best practice for families. And we know that, right? Like we want to know when our families are being coming under the purview of the state. I just was on a presentation that I was watching that was about data, about placements and removals and investigations since 1978. Like, what does the data look like now versus pre-ICWA? And I think it was something like 80% of Native children in Minnesota will be investigated for child protection, like in their lifetime, right? That's so hot, that's unacceptable, right? So yes, every tribe would love to know. I mean, yes, we know the minute, and we would love to jump on it as soon as we know, because we want to be there for every single one of our families that is coming under the purview of the state of Minnesota. The capacity is the issue, right? So tribes have a process in which they have to get that family information, and then they have to determine eligibility. And then when you have out-of-state tribes, they have liaisons that then have that additional step in liaisoning with the out-of-state tribe to determine eligibility. That means sending the information to the enrollment office and then waiting to hear back if that family is eligible for those ICWA services. And every tribe gets to determine who is eligible for their ICWA services. So at Red Lake Nation, we have a descendancy resolution. So we extend ICWA protections to the children of enrolled members, or if the parent is eligible to enroll their child, regardless of that child's enrollment. And then that is the tribe's sovereign decision. It's also the tribe's sovereign decision to involve ourselves and deem something an ICWA case. If you're ever in a hearing and they say, and this has happened to me, let's go around the table and ask, does everyone agree this is an ICWA case? It's not okay. That's not how it should be happening, right? If the tribe intervenes and said this is an ICWA case, it's an ICWA case, right? Like ICWA is an extension of tribal sovereignty. It is tribal sovereignty in action. And that's how we train our workers at Red Lake Nation. And that is the sort of bottom line of our practice at Red Lake Nation. Does that get to that?
Yeah, I think
Okay.
so. Can you also talk about, so I think you covered that. You want to talk about active efforts as well?
Sure.
Or did you have more to say?
I always have more to say.
You've got 5 minutes left in that.
I think I could say more about active efforts, so I'll move on and use those minutes there. And I have to remind myself that, in the past, and I think all the ICWA workers in the room can relate, we're used to talking to county workers and state workers and sort of like, teaching from that perspective of, you might not know what you don't know about Native families, or you don't know what you might even be looking for in that cultural piece, right? But I'm kind of having to shift my mind because this is a different, venue. So stop me if I get too over here with whatever. So active efforts for family reunification. How can the tribe be proactive, and how should the county work with the tribe before court involvement? So again, in this scenario, imagine that capacity of a tribe is not the issue, right? Like, because sometimes you may want to be consulting and it's just simply not, like, we struggle with that all the time at Red Lake. We have set a precedent, I think, that we expect consultation on everything. So we get a lot of requests and we always just kind of field those. But I think that's the way it should be, that no matter what, you need to kick it to the tribe to decide if they want to consult from day one, right? So you need to be emailing, you need to be calling, right? And you need to be saying, this is your family and I want to consult, right? And then give the tribes that opportunity. But the other end of that is being respectful as if you're, again, a county worker, right? County workers need to be respectful that tribes have limited capacity. And so in the way you ask, right? The way you ask for consultation, the way you ask for QEW, the way you approach the tribe in involving them, that matters too, right? Because at the end of the day, it's about relationships, right? And relationships are going to help our families survive this system. And tribes want to be there for our families to help them survive and get out of this system. And so if we can have good relationships and good communication, and be respectfully heard when we're saying what we want to see done for our families that are in the system, that's going to go a long way, right? So ICWA says that you need to do active efforts, and MIFPA does too, right? Active efforts for preservation, reunification, and concurrent permanency planning, right? So I think sometimes the preservation piece gets really glossed over, right? I think there is a practice in child welfare, and I think that is the way our child welfare system is set up, that fear-based decision-making leads to making holds, removing kids, and asking questions later, right? But that's not acceptable practice. And it's not acceptable practice for any children and families, right? But it's certainly not acceptable practice in the Native community where there is such a history of removal, and then never asking questions later, right? And so that is the practice that we see, right? Oh, we did a hold, but it was just the easier, safer thing. But don't worry, we really want to reunify the family. Well, yeah, hope so, right? And so, but the preservation efforts and the consultation that comes with that is really key. And in my observation is sometimes missed, right? But what that looks like is, it's trusting the family. And it's trusting the tribe that we may know or have different questions to ask. The family may know or have different ideas about what safety looks like, and to uplifting those and centering those, right? So if we're consulting on a case, safety might look different because we may see a risk factor, but we may not see that as imminent harm and danger, right? And if we're pushing back and we're asking, well, what about this, right? Or there is a family member that would be a great family arrangement, and that person may not look like the ideal foster candidate like a foster care candidate on paper, but we can mitigate safety factors with planning and clear communication and uplifting family strengths. All right, let's go with that, right? Let's get that family out of the system. Like, I think at the end of the day, families do not need to be, I know at the end of the day, families do not need to be in the system to be safe, right? And so it's just sort of like we're using these tools we have that no longer work for families. And I think the biggest, have never worked for families. And I think the biggest opportunity for growth in changing that is doing preservation on the front end and heavily consulting with tribes, and also consulting with the family. Like, what does preservation look like for you? What do you need? Who do you have, right? And understanding that if there is a viable family arrangement and that family is going to step in, and the tribe has helped to identify what that viable family arrangement is, that the state does not have to control every aspect of an Indigenous family's life. And so if you have a family arrangement, we can tap out, right? Like, we can close that case and trust that we have done the work on the front end to help the family. Now, when cases sort of exceed the capacity of that family to provide safety, and that those efforts have been exhausted, right? And those people have been exhausted, that should be a last effort. It should be the last choice you make, to formalize out-of-home placement. And as you're moving toward that most restrictive, most invasive thing you can do in a family's life, you should be consulting. See, this is like I'm not talking to county workers, you should be. No, we all should be consulting with the tribal partner ongoing, right? And sometimes in practice that can look really hard, like I said, because of capacity issues. But I also think that for tribes, right, if we can advocate to our organizations and to tribal council and have that data that shows that front end consultation, front end tribal involvement goes a long way for families, that is advocacy we can do within our own organizations and within tribes, right? To show that it matters that we have the capacity. You know, and I was giving a presentation one time and I was talking about this, and one of the questions from a county worker was like, well, what if we can't consult with the tribe prior to removal? And I'm like, why should the tribe be the only factor keeping you from removing those kids, right? Like, can't you think of other things that you could do in your practice? The tribe, it shouldn't be we didn't remove them because the tribe was there. It should be we didn't remove them because we did active efforts for preservation and we exhausted every least restrictive option before going to a really restrictive option of out-of-home placement. What else?
Well, we only have a few minutes left. Thank
Okay.
you so much.
Yeah.
You're doing great.
Okay.
Maybe we could, is there anyone else on the panel that wants to say anything about active efforts or what they are, or just share with our audience?
I think, Teresa.
Go ahead, we just pass it to your official.
Hi, Elise here. I just think that Teresa covered that really well about the active efforts piece and then the preservation for families. So just want to say thank you to her. Thank you.
One more, I'm gonna say one more thought. One more thought, I think, is that helping collaterals and people who are involved with families to understand that active efforts, there is a spirit of active efforts, right? And that is the relational spirit. And then like the legal spirit of active efforts. And then there's like what active efforts are on paper, right? And I think that there is sometimes a misunderstanding of what that is. So you'll read a petition. I'm not making this up. This is all examples, right? Like somebody put in a petition that active efforts was helping the children pack to be removed from their family. Like, who thinks that's active efforts, right? So, I mean, it's a misunderstanding of what that really means, right? And then it's not just the tangible things that are done for a family, like bus cards and, you know, rides. It's the time, like the best active effort is time, right? The time you take to get to know that family, the time you get to take to get to know their tribe, and the really like clinical heart of child protection work where, hey, you know, this child protection system it's invasive and traumatic and disruptive to families, right? And so as social workers, like in child protection, it is our job to repair, right? Like we're connectors and we connect and we repair. So it's not that I'm just going to drop you a card and be on my way and I put in my petition, I've done active efforts, right? No, it's I sat with you, I heard from you, and then maybe there's a conflict between a parent and a relative care provider, right? That's what we call foster providers at Red Lake. And instead of saying, oh, that's a family thing, figure it out, how can we help mend that relationship? Likely the conflict is because of the involvement of the state, right? So that falls on us as workers and as the state workers and as tribal workers to say, I'm going to help you get in connection, right? I'm going to help you build a bridge. I'm going to help your family find what it needs to heal from this experience of child protection too, right? So I think active efforts is sometimes misunderstood. It is not just what you do that you can make a list of and put in your court report. It's not just these tangible items. It is the actual like spirit of the relationship you're building with families and tribes.
I might, yeah, sure. First I'll get everything in position. So just to dovetail off of those comments about active efforts in a non-ICWA case, the social workers and the social work team, they have to make reasonable efforts. Active efforts are a step above reasonable efforts. So active efforts doesn't just mean we actively made some kind of an effort. Right. It's really above and beyond. It's a pretty high standard that people are expected to provide for these families. And those active efforts are one, make active efforts to prevent the removal in the first place, not make active efforts to help them with the removal. And then you later on in the case, you get to active efforts to promote reunification or active efforts to achieve some kind of a permanency. And, you know, there's tons of different examples that you could go into of what aren't active efforts. Just something that sticks out to me to distinguish kind of reasonable efforts in that standard versus active efforts would be, you know, say that you have a parent and one of the issues that led to the removal is a substance use issue. Reasonable efforts might be, you know, I as a social worker made this person a Rule 25 appointment to go and get an assessment, and I, you know, help them figure out where they might go for treatment. Active efforts is I made them an appointment to get a Rule 25 assessment. I drove them to the assessor's office. I counseled them or I worked with them on the recommendations to get them into a treatment facility, and I drove them to the treatment facility, and just it's a greater level of assistance. So I think we talk all day about active efforts, but I just wanted to kind of dovetail off of those comments a little bit.
It's really helpful.
So
I think, oh, sorry. Yeah, we're already at time just about. So we are going to be going next to just a heads up to, I think, Kelly and Michaela to talk a little bit about out-of-state tribes. But first, I just wanted to add a quick piece on about active efforts. Just that I would say, like, you know, for families, anything that families feel like would be helpful to them really is an active effort. So if it's something financial, that's like something that's blocking your way from getting something done, that's probably an active effort that could happen. Like some examples could be, you know, maybe you would like your children to be in the care of a relative, but your relative doesn't have, you know, maybe is in a type of housing that they can't have children there or something. Maybe they're in senior housing and they're willing to move to a different place, but they have to somehow make that happen. Those things are active efforts. And those are things like that your tribe and your county social worker and any advocate or anybody else that you're working on, if you bring that up, then those are things that they're supposed to work on with you to try to make that happen as much as they possibly can. So just from a family perspective, those are always things that I always say, you know, you just ask, because sometimes we don't always know what are the things that are kind of preventing things. So yeah.
I'm so glad Laura said that, because that's so important, right? And I think a lot of times families, don't know, like Laura was saying, what they can and should ask for. And then I think it's so important to name there is a power dynamic, right? And unfortunately, so many times our families want to ask for things and they get maybe too afraid, or a county will say, no, we don't have that. But always go to your tribal worker in that, right? Like your tribal worker is your advocate in that, as if you're a family in the system, and your tribal worker can ask again. So like, it's kind of like the take 3 no's rule, right? Like just keep asking, because at the end of the day, we have to remember that we're working with vulnerable families, right? In a system, and families are in a resource deficit, and the systems that hold the power in their and having custody of their children, they're not in a resource deficit, right? They might say, oh, we don't have it, right? But this is a state and county system. You know, they got to try to find it. That is their active effort, right? So if it is a resource issue that is blocking their active efforts, get with your tribal worker, get with your attorney, and push back and say, listen, you either got to find it or you got to work on your policies to make it different, because you are not meeting the expectation of active efforts if it's constantly no's for these resource things when you're working with families who are in such a resource scarcity.
Okay, great. Thank you all so much. I know that there are questions popping up in people's heads as we go through this. Please write them down. We are going to have a Q&A portion. Just going to read this one so that our panel here can kind of be thinking about it. This is a question from our audience, and you know, they might have different answers, so I'm going to give them a chance to mull over for a little bit. So who would hold a non-native child protection worker, or really any child protection worker, accountable for actually following through and actually implementing active efforts before removal? And then where do I obtain a copy of the descendancy resolution? Is that regarding Red Lake? Was that what you were talking about?
I was talking about Red Lake
Yeah.
specific, yeah.
Okay. So I think those are the two questions. Maybe you can answer the Red Lake one if that's.
Yeah, I mean,
easy.
it's a tribal council resolution, and so I'm pretty sure those are just, available for people. I have a copy of it, and I would be happy to share my email with whoever asked that.
All right, so I think we're gonna go to Zoom now to Kelly, and then also Elise is here in the room, so that might be a little tricky. Both of these folks are part of our Minneapolis American Indian Center Tribal Liaisons. What's really great about Minneapolis metro area is that we have this service. Most of the rest of the country does not, so we're really lucky here in the metro area to have a liaison program. They do work with tribes all over the country. We have special memorandums of understanding and agreements with them in order to speak on behalf of their cases in court. And so, yeah, I'll turn it over to them. Go ahead, Elise. Or Kelly, whichever you want to speak first.
Okay. Hi, my name is Kelly Morgan. Bonjour, everyone. I'm the Tribal Liaison Supervisor, and I've been with the program for 12 or 13 years now. I forget, I've lost count. And I worked with some of the out-of-state tribes. My biggest one is Spirit Lake. Standing Rock. Spirit Lake is another one, but Standing Rock is my biggest. So my topic is, why is my tribe not involved in the case? So there are different reasons. Tribes in different states may use different definitions of an Indian child. Eligibility and definition of an Indian child blood quantum. Yeah, that's kind of what I was thinking when I read the first line. The definition, some go by like the descendancy and some go by, they're not gonna ever be, enrollable, they're not gonna be enrolled members themselves, but they are an ICWA case for purposes of ICWA. And so, and then I think there's other, reasons that the tribe isn't involved in the case. And that would be, I think sometimes for us, we get some tribes that are like one tribe that's kind of out in the middle of nowhere and doesn't know who we are and what our role is, what we do, and don't respond to us, and we can't, they don't really, so they just don't realize how much we can actually help them, and they don't have the resources themselves to be able to help this family. But so they, maybe they just feel they're unable to help. And sometimes it takes, okay, they have another family a year later, and we try again to connect, and we do make a connection, and they do listen to us, and when we explain our program, and they're like, yes, we're really interested in, we'd love to have your help. We just, we don't have the resources or, the staff to come, be involved. And so we usually don't get involved. And so that's another reason that the tribe would not be involved in the case. I know we discussed this the other day, Elise. I don't know if you.
No, I do remember this conversation. So this is Elise again. I Kelly and I did speak about, what reasons why tribes would not be involved in the case. And she did mention it a little while ago. And it was about tribes may not know of the services at the Minneapolis American Indian Center with the liaisons. I think it also has to do with Teresa said it best, tribal capacity. You know what, and I refer to it as people power. There just might not be enough people in place that could take on, the out-of-state cases and refer to us. So a lot of that has to do with us as building relationships with out-of-state tribes, or just letting know that, this is our role, this is who we are, this is how we can help. We also, have authorizations, and I forget how many out-of-state tribes that do, request us to be a part of, or at least, sit in on some of the out-of-state hearings that take place both in Hennepin and Ramsey County. Kelly, am I missing anything?
You just, made me think of another thing, and that was that they might think, that it's too big of an obligation to try to get in on another case because of the calls that they would get, and all that, because of the last time that they might have had a case there, or and here they don't realize that it would be just the one person that they would be dealing with. So that's another good, point about having a tribal rep and our tribal liaison. And
sorry, Kelly. Can I
Yeah.
talk just briefly about, kind of the differences with some of the tribes that you work with, as far as we talked about capacity, but really what their resources are. For example, how many workers does one have right now that do cases? So 8 workers at Red Lake, 7 workers at Red Lake. Can you kind of just share some of the tribes you work with, how many people do they have?
Oh man, I have one, one of my tribes only has 1 worker. And so she's the person that's, I got to wait for her, and she's got she's up there in age, and, with health situations. And if she goes on leave, I got to really be there to figure out what am I going to do,
Yeah.
I want to be sure that we're, staying involved and stuff like that. But, and then there's other where there is more than one, but most of our tribes, I think we do only have the one contact person. And then, they might have, there's a, tribal, attorney, but they aren't usually involved in our ICWA cases because they're involved in the tribal aspect or their tribal cases. So
I run into that too, Kelly. It's just so in one of the tribes in South Dakota, I'm told that, I'm in communication with the ICWA director, but the correspondence between us isn't, it doesn't happen, right away. So when I'm reaching out, it's just I'm also waiting to hear back, or when we're sending out verification requests for enrollment, we don't get that back right away. And so then it leads to emails and phone calls and voicemails. And then you're also getting calls from the counties and saying, this is what we're needing. And it's just we're working on it,
yeah.
However, it's the turnaround time, isn't as quick as some may think. One thing that I learned was that because I'm housed under one roof with the rest of my team, and that's not the case with one of the out-of-state tribes that I work with, and their enrollment office is in one part of the state, and their their ICWA director is housed in another place. And in some cases, they are also working remotely. So it's reaching out to multiple people, but not getting the response as quickly as, you know, what is requested. And so it gets a little, from the county. I mean, I've had the county reach out to me numerous times, waiting for QEWs or have you heard about enrollment, and I haven't. But it doesn't mean that we're just like, we're still reaching out, we're still asking. It's just like just following up.
Yeah, that is true. People are still working remotely, and some of those documents are slightly behind schedule.
Absolutely, absolutely. So, you know what, I mean, I reached out waiting for verification, and I was told that, you know what, there are 2,000 people in front of you. And so in order for, basically just for me to get in line and wait my turn.
Oh, yes, these would be like enrollment eligibility kind of things because of the ARPA funds being distributed and people rushing to get enrolled and, you know, stuff like that. It all goes through the enrollment office. So that's another reason that kind of gets hung up.
I think we're actually out of time for this topic, but we.
Okay.
Thank you, Kelly.
Yep, you're welcome.
Yeah, if you want to stick around for the panel, we could sure use you then, if you're able to. So I know, you know, that's a lot to cover. There's a lot to cover in a short amount of time. One of the reasons I wanted them to come speak is because there can be like vast differences between our Minnesota in-state tribes and some of the resources, and maybe some of the tribes that we work with in North or South Dakota or Wisconsin, or other tribes around the country. The other thing that I don't think Kelly got to mention, but just to let people know is, you know, in the state of Minnesota, what's really nice, I think, is that some of the tribes have been able to adopt, you know, the ability to recognize families for ICWA purposes. But we don't have many of our out-of-state tribes that we work with, at least, that do that. So that's one of the nice things. Like if you're from a Minnesota tribe, you know, you might not have your children eligible to be enrolled, but they might be able to be recognized for ICWA services. Unfortunately, for some of the tribes that maybe are more impoverished, don't have the same amount of funding, or have large populations, and less workers, they may go by, you know, a federal blood quantum, and say, well, unless the children meet this particular quantum, you know, whether that's 1/4 or whatever they state, you know, then we can't be involved, which is tough. So I guess the piece that I would say to families is, you know, those are times you get involved in your own tribal politics and, you know, raise your voice that way and talk about enrollment and how it affects people and individuals. But it's not, unfortunately, something that we can change. But we would love to see all of our families be able to be, you know, eligible. But sometimes it's got to happen tribe by tribe. So I think that we are kind of out of time for that. We've got to talk about QEW process. We kind of skipped over this a little bit, but your tribes are able also to be involved in your case plan. So if you are a family that's working with child protection or one of your relatives, and you know, you show up to a meeting and your tribe isn't there, and you can ask and say, you know, was my tribe consulted about this? Or, you know, have you called my tribal worker? Because they should be, you know, they're supposed to be at the table. If they can't be in person, you can always do something on Zoom or be on the phone, or even a, you know, conversation beforehand, or, I mean, lots of different ways to do that. But, you know, tribe, like Kelly and Michaela, they're on Zoom all the time, on the phone all the time too, to try to make it to all the different meetings all over the place. And I know all of you guys do too. So, and we're gonna hand it back to you too, Teresa. So we'll just pass the
Is it, I
camera
think
back.
it's NIFA, right, that says if the case is, you know, if a family has said, yes, I have Native heritage, doesn't matter if they said, I think I'm Ojibwe, right? Like, they have to notice every Ojibwe tribe in whatever state, right? And so, and they can't decide, that the state cannot decide that it is not an ICWA case until that has come back that it is not from the tribe, right? So they have to treat it as an ICWA case and do the standards of active efforts until it is definitively not. And I think as families, it is so important to know that, right? Families have to know that they have that right to be treated as an ICWA case until their tribe makes the sovereign determination that it's not. It's really important. But Ben's gonna help me talk about QEW. I picked it to him. I feel like I've talked too much. So
So, all right. Thank you. So one of the acronyms that you're going to run into in any kind of a child protection case concerning Native children is QEW, and it stands for Qualified Expert Witness. A qualified expert witness is someone who is an expert on the child raising practices that are part of the child's tribe, the child that's subject to the child protection case. You need, and the significance of this qualified expert witness is that you need their testimony, often in the form of just an affidavit rather than courtroom testimony, but you need their testimony in order for the court to continue any kind of out-of-home placement of the Native child. And that's true at every point in the process beyond just the initial emergency hold and the initial hearing. At that point, they don't need the QEW's testimony or affidavit to remove the child. But after the initial hearing, you need to get this report from a QEW, or this affidavit from a QEW. And basically what this affidavit will say is, you know, I'm an expert, I'm from the child's tribe, I'm an expert on child rearing practices, and the things that are going on or alleged to be going on in this case are not consistent with the child rearing practices of the tribe. So that's, if you can't get somebody to say that, to give that opinion that they're an expert on the child rearing practices and they believe that out-of-home placement is needed and justified it, if you can't get that, then you can't have that out-of-home placement. So usually what will happen is, well, I guess I just know from what I've seen is a lot of times after the band that I work for, the Mille band, has been noticed and brought into the case, if the band has evidenced or indicated in some way in the court proceedings that we're in favor of the out-of-home placement for now, a lot of times the county attorney's office will reach out to my office and say, you know, can you help us put this together and put this affidavit together? And we have a couple of people who are the qualified expert witnesses for our tribe, and I'll go through the case with them or give them the file and answer any questions they have and tell them what's going on. One of the things that's about a qualified expert witness is that it's solely within the purview of the tribe to designate someone as a qualified expert witness, and people can't come back and say, you know, she's not really an expert, because the tribe is in the position to know who has expertise in this area and who's not. So yeah, typically the qualified expert witness is, sometimes I think maybe the social workers reach out to the tribe, and it's social workers. A lot of times what I see is the county attorneys or the deputy county attorney in charge of the case reaches out to me and we discuss it. But it's powerful leverage for the tribe, because if you can't supply that or you're not willing to help them get that from someone, then the out-of-home placement or the continued out-of-home placement is a non-starter.
So it's also required, so QEW is required for a termination, right, of parental
Yes,
rights.
yep.
That's required, but a lot of counties will extend that practice, since most tribes don't do TPRs. You know, that statute will be interpreted that, and Red Lake's practice is that a qualified expert witness should also be provided for any permanency decision, not just a TPR. And I think that, you know, on a systems level is something that is really important, because say, you know, you have it's part of the ongoing consultation and collaboration you do with the tribe, right? You give the QEW the first 30 days of someone's crisis, their worst day on paper, right? And then you're never asked again if you think that child should be permanently separated from their parent because of that worst day on paper, and you don't ever get to reassess that scenario as a tribe. You know, that's just not best practice. And so a lot of tribes will give QEWs for all permanency decisions, which I think everyone should do. And I think everything should be that way. But that's really important. At Red Lake, we have a team QEW process, so it has to be like unanimous agreement from our whole team. And then that we will actually, I don't know if Non-ICWA does this, but we'll edit the affidavits that the counties send us, and
Yes.
we will put in like lots of language about contact and tribal expectations and just different things that as we're staffing through the case and thinking about the best interests of the family, we will put in different language that comes from the tribe, right? And then if our QEW were to go to trial, you know, they can get cross-examined, right? But their qualifications
Their
cannot be questioned.
qualifications. can
Right,
be-
because we
but they can
determine.
be questioned.
Yeah, so that's really important. And then it's important to remember too that when a county is removed a child, they have to prove that there is a standard of imminent harm and danger, right? And the QEW solidifies the belief that there is imminent harm and danger. It's not just risk. It's not just, oh, I wish things were better in this family system. It is imminent harm and danger, right? And there is a difference of that, right? And so you have to understand too that how different systems define imminent harm and danger could be different. And so you might find a lot of push and pull, right, with QEW, and a lot of tribes might have a really strong stance on what that looks like. Thank you. And so as a family in the system, it's really important to know you have rights around that, and that if you know there is not a QEW on file from your tribe, be asking, hey, has my tribe supported this placement? Is my tribe supporting this? Always through, your tribe is your advocate, and that's the same in the QEW process.
Can you switch it? Can you, I can't read this one. All right, so I know we're getting some more questions about QEW. We're going through them all here so we can make sure that they're answered and kind of combining a few. What we want to talk about just briefly now is a question that a lot of people ask, and that's what happens if my case doesn't get recognized as an Indian child welfare case? So, I mean, we know, you know, my own family included, if like my child or grandchild was to be involved in the system, might not be eligible for ICWA purposes because of blood quantum. You know, depending on which tribe you're from and all of those types of things. So sometimes those things can come into play. We have lots of families that we work with. I'm sure everybody knows, you know, you've got parents from a dad from one tribe, and you know, maybe they're Ojibwe, and you know, the other parent is Cree, and maybe neither tribe count the other's blood quantum, and then it just turns out that they won't be recognized, which is very unfortunate. So we want to just briefly talk a little bit about what happens when that happens. And we've got in the metro area, at least, we do have the Indian Child Welfare Law Center here. And so I know that Andrea is on Zoom with us. And so I just wanted, if she could briefly kind of state how the ICWA Law Center handles those cases.
But my name's Andrea Sanders. Yeah, I'm a legal assistant at the ICWA Law Center. And as Laura said, we're in the Twin Cities. We do, we act as basically the public defender's role in Hennepin County. And so anytime there's an ICWA case that comes in or it's identified, it doesn't necessarily have to be established by the tribe yet, but if the parents or whoever the party is have identified as Native, then it's counted as Teresa said, it is treated as an ICWA case until it's known otherwise. Now, if the case is found to be non-ICWA, we stay on the case. We don't hand that over. They do, usually they might be assigned another judge who's not in the ICWA unit. Hennepin County has their own ICWA unit, so they have their own attorneys that are ICWA, they have their own judges that are ICWA. So those will get reassigned, but we will carry the case through to the end if it's not ICWA. Some of the other things we can do, which we have just started doing, is once a case closes, we have a parent mentor and an Indian advocate, both who can still help to navigate services and to help coordinate program and services within the community with other service providers. If we have a client that whose case might have closed but is still looking for housing, we can help them find resources, or possibly having to still, if they have to go to meetings, we can refer them out to other people. We also can do, even though we're typically doing mostly ICWA cases, we can do some services in coordination with their case plan, like maybe they need an expungement on an eviction, or they need help clearing up warrants. So we can do smaller things like that if it's, if those are detrimental or they're in the way of their ICWA case, we can also help with that. And then we also have been trying to offer some services with our Indian advocates and our parent mentor before a case is open. So if somebody gives us a call and they say, I'm being investigated, or I'm worried about this and I need to get some programming, or I have to meet with somebody and I really would like somebody there with me because I might not understand it, or I want somebody to help navigate it, then we can have one of our advocates also help with that. And one of the other things that we do is let's say a case closes and if our client is mom and there's been a TLC to grandma, and a year, 2 years, 3 years, whatever it is down the road, mom is in a better situation. She's able to care for her kids now. We can help to modify that transfer of legal custody, or help to vacate it, or help mom get the kids back in her care. The only caveat to that is that typically the grandma or whoever the new custodian needs to be in agreement with that, and as long as it's not contested, then we can go in and help change that custody back as well. I think that's about it, unless anybody has questions or.
I think that covers it, Andrea. Thank you for talking about the Law Center.
Yeah, okay, thank you.
And we might have another question when we get further. They're kind of popping up as we go.
Sure. Okay.
I think maybe just the other thing I would mention, so, a lot of times people ask like, well, okay, maybe they don't have a Law Center attorney and their case has gone non-ICWA, what are the resources that they can get? So if you're in the urban area, speaking as some folks are here from the urban area, there are numerous organizations that you don't have to be ICWA eligible. You just have to identify yourself as being Native American to receive services. Like, many of the people are in our MUID Family Preservation Subcommittee. So the Minneapolis American Indian Center and Andrea and the Minnesota Indian Women's Resource Center, DIW, the American Indian Family Center in St. Paul. There's many, I'm missing some, but and as well as, sometimes I think the tribes, even though they might not have, have an ICWA worker that could work with you, they might have another program that you still would qualify for. So I always, encourage people to reach out for those things, because a lot of times those workers in those programs can also be advocates. Now, they might not be able to come on the court record, but a lot of times they also have communications with county workers. They know what services there are. They can definitely still be very helpful to families. So that's something to look at. There also are, just a number of other services that are for families just involved in child protection that might not be Native specific, but there are visitation centers and, you know, other places. And a lot of the folks that work in those places have worked with lots of families that have kind of gone through the system process. So those are always good people to reach out to. So I just encourage families to find one of the programs that they're working with, even if their tribe isn't involved, or maybe they don't have an attorney who's versed in ICWA or their case isn't ICWA, to talk to them about their case and what they might be struggling with, because there's lots and lots of advocates, and any advocate can help advocate for a family in any way. So I think that we're rounding out on time for that. We've got time. We're going to head over to Ben for a little bit to talk about transferring cases to court. I did want to bring up our first question here before you start, just so we kind of get through a few of our questions. So there was the question that asked, who holds the non-Native child protection worker accountable for actually following through and implementing active efforts before removal? And also, how are they accountable to do MIFA notices? If anybody wants to take that question, feel free. Anyone from the panel or on Zoom?
I can take that one just quick. So, I mean, the law, right, is one, but there's not, there's not a compliance process for ICWA, but in Minnesota, we do have a compliance process, or like nationally, there's not a compliance process, but in Minnesota, there is a compliance process. So you can make a compliance complaint to the state of Minnesota, and they will look at that. But really, just real talk, what it really comes out to being in real time is the tribal worker, and some of the collaterals that understand ICWA and really understand what is needing to be done and is seeing what is not being done. So I always say, tribal workers are doing so much consultation and training. They should be paid so much more, right? They should be paid consultant salaries, because we are doing so much like on the ground education, and then the way you can hold people accountable is not only through that education and that dialogue, which again is that emotional labor from the tribal worker, but of course in court, putting things on the record, utilizing tribal attorneys, and then I don't know, what else would you say about that?
So I was just going to say, one, your attorney should bring this up. Two, the tribal attorney, if the tribe is involved in the case, or is intervened in the case, and three, the judge can and should hold the social worker accountable. And I think part of the question was, what if they didn't follow active efforts before removal? I mean, they can remove before there's a court hearing, but at the first court hearing, I suppose, you could raise, there's no reason to remove the child. There's not a emergency here, and your attorney could argue that. You could voice that, and the court could say, I'm throwing this out. I'm dismissing this because there's not the necessary emergency or justifying this.
And then the tribe could refuse the QEW, right? So you could go that 30 days of emergency placement, and then tribe refuses the QEW. I do it plenty, right? And then that kid gets returned, and then that doesn't mean you're just leaving the family high and dry, right? You're going to do safety planning, you're going to do supports, you're going to maybe you get a second chance at active efforts to keep that family together. So the QEW, especially for tribes that can't be there right at the beginning and kids get removed, maybe it even takes us some time to get involved with court because we are just so inundated, right? We still have that QEW to be able to say, I know we maybe are late to this game, that's not our fault, right? But we have evaluated this and we do not believe placement's appropriate, and we'd like the child returned. So that QEW is this powerful piece from tribes for accountability. And tribes can intervene in a case at any time. So if you are late to the game, or you don't get the notice for a long time, you can jump in. Okay, so I think I'm up, and I'm just going to talk about some differences between tribal court and state district court within the context of child protection cases. And I'm also going to talk about transferring cases from state district court into tribal court. So I work as a Deputy Solicitor General for the Mille Band of Ojibwe. So I represent the tribe's family service department in child protection cases that are in tribal court. And then I also represent the tribe
as an intervening party in state district court cases that are child protection matters that concern a Mille Lacs band member enrolled or enrollable child. So I'm involved in both tribal court and in state district court. And as far as the differences between the two, I don't want to paint with too broad of a brush, because as far as tribal courts are concerned, the only tribal court I practice in is Mille Lacs band. So, but I think some of this is, from what I know, is generally applicable. I would say the biggest difference between state district court and tribal court is typically going to be less adversarial and a little bit more informal. You know, in tribal court, you might have different family members that are present with something to say or something that they want to be heard on. And generally in tribal court, the judge will allow these different family members to have their say, and somebody might talk about an issue or raise something, and then somebody else that's there might respond directly to that. And it just feels more, I might have already used the word conversational, but I think that's the best way to describe it. I think that part of the reason for that is that tribal courts are, because they're non-adversarial, they're kind of trying to allow this to be a forum to build consensus and help everybody understand expectations and where we go from here. The other difference I would note is that a lot of times your tribal courts are going to be taking into account different cultural values. So, for example, right now up at Mille Lacs, our courtroom is under reconstruction or being renovated, but I believe prior to the renovations, the way it was set up, you had the Anishinaabe 7 values up on the walls in there. So that was something that was always in play and was supposed to be incorporated into this. You know, at the same time, tribal court is still, you know, a system of complex, you know, written statutes and laws, and there are rules of civil procedure and courtroom procedure, just like in state district court. One thing I would note, we've talked a lot tonight about ICWA and the Indian Child Welfare Act. ICWA actually doesn't apply in tribal court, because through tribal sovereignty, tribes are allowed to promulgate their own statutes and their own procedures. But what you'll typically see, I think, is that you have tribal codes on child protection that are reflective of the things that are in ICWA. You know, for example, at Mille Lacs, it's codified that, you know, social workers need to make active efforts. It looks similar in terms of the hierarchy of placement preferences for out-of-home placement and for permanency. But yeah, tribes are free to make their own statutes as long as they don't violate the Indian Civil Rights Act, ICRA. Just another difference is just kind of the timing of different types of review hearings or court hearings can be different. With the Mille Lacs band, we don't have the same timeline for permanency as you do in state district court. There's, you know, you're up against this deadline to reunify. In tribal court, you know, because these tribal courts are free to have their own statutes, you might not have the time limitation to reunify that you're looking at in state district court. And you might not have the same vehicles for effectuating permanency if you're unable to reunify in state court. There's a permanency petition that facilitates permanency with somebody else. In tribal court, a lot of times, rather than the attorney filing something and nominating somebody else who's a foster parent or whoever, you might be kind of waiting for someone to file a guardianship petition. Although we've just revised our statutes, and now we have a transfer of custody petition that we can file, which is kind of the closest thing to the permanency petition you'd see in state court. So just really briefly, I'm just going to talk about transferring to tribal court from state district court. So why would it be in state court instead of tribal court if it involves a tribal child? The answer would just be because of where the child is located. So, you know, if it's a Red Lake child, but the child and the family are in Hennepin County, it's going to be Hennepin County that's filing the case a lot of the time. And so there are different mechanisms for transferring that court to tribal court. Under the Indian Child Welfare Act, you can seek to have the case transferred to tribal court, and the court shall transfer to the jurisdiction of the tribe absent objection of either parent upon the petition of either one, the parent or Indian custodian, or two, the Indian child's tribe. So those are the parties that can request it to be transferred. And that's also provided that such transfer shall be subject to the declination by the tribal court of the tribe. So you can request transfer and it can be transferred as long as there's not an objection from the parent. But the tribal court may or may not accept the transfer. And then you're also, each tribe is going to have its own tribal court rules for what cases we accept and what's involved in that. And you may have to do something in tribal court before you get the case transferred in the transfer order from state district court. Why would you want to transfer? I guess one, you might feel like you're not getting culturally appropriate services, or just the services period that you feel like you need from the state or from the county that you're in. But on that note, I would say that I have had the opportunity to work in some counties where they do a really good job. They have dedicated social workers that only handle ICWA cases. But that's out there as an option, is transferring to tribal court if you can get the tribal court to accept transfer. So I don't know if anybody else has anything.
Can I have just 2 questions? Sure. Yeah, so just 2 very quick things about that. The timelines, you can fight those timelines in state court. Like, they are not a death sentence, that the counties will act like they are. But if I have gotten a tribal attorney and I have put in a motion and I've gotten a ruling that, yep, there's good cause to extend timelines, right? Some counties really adhere to those timelines, others don't, but they are, you can fight them, you can push them, and that your tribal worker through a tribal attorney to motion for that for good cause is your best bet for timeline extension. And then also with tribal transfer, the tribal capacity issue is a big deal, because that is a distance from the actual physical tribal court. The resources can be difficult. So you may find that your tribe denies the transfer, and that's because they might have it be like only if they're going to terminate rights, and it's that last ditch effort. But a lot of tribes do not have the capacity to take as many tribal transfers as we want, so.
So we're going now to our parent panelist, Shayna. Welcome and thank you for coming tonight. Go ahead.
Okay, I just want to express my gratitude for letting me come and share my experience with you guys. I want to talk about my experience with having a CHIPS ICWA/ICWA case. My first experience brought a lot of hardships. My kids were taken out of the home. I didn't have a clue as to where they had been placed. I wasn't able to see nor talk to them for about a week, which was nerve-wracking and of course heartbreaking. In that time, my PTSD and anxiety were over the roof. I felt very helpless, hopeless, and severely depressed. My first appearance in court was somewhat of a relief, because I heard I had an ICWA worker. Not knowing what ICWA was, I had questions. So as soon as they responded that Red Lake was intervening and stepping in, I just got chills down my whole body and started tearing up, because let me tell you, being in that courtroom, not knowing what will happen to my babies, because all you hear is bad things about the system is one thing, but hearing you have the support from your tribe is definitely another. So I walked out of the courtroom feeling like I had a chance to fight. I was able to obtain all the necessary supports I needed thanks to the resources I was given through my ICWA workers. And I say workers because I didn't have just one open case. I had 2 different cases at different times. With that being said, I fought and got knocked down a few times, but I got right back up, because truthfully, that's how the system wins. I didn't have it in me to give in or give up because those are my children. I did what I was asked to do to be able to even see my kids. That seemed like a very long time. I did that for about a year and a half until my case was closed. 2 months after I won my first case, I was before the judge again this time around. I accepted and took full responsibility for what I had done to get the second Chips ICWA case. The difference between this one and the last one is, I think the second time around, I was ready for a change, and I pretty much surrendered. And I already knew what was needed to be done, and I ran with it. I had even better supporters behind me, and my understanding of what I needed rather than what I wanted made all the difference. As of today, I still often wonder where I would be if ICWA wasn't a part of my journey. ICWA actually made it possible with the resources and support, which was sometimes overwhelming, but in a good way. Let's see, with all of this behind me, I was in front of the judge in no time with my kids in my custody and case closed for the second time. So today I maintain contact with my ICWA worker. I'm in good spirits, in recovery. I work with those still struggling by guiding and supporting them. I help parents with resources, and I also started a support group for women. And I'd also like to tell the parents who are fighting the system today to never give up hope. You are not alone in this. Reach out to your ICWA worker, your support system, and get them resources that are available. And that's that. Thank you.
Me good, Shayna. That was so nice. And thank you again. If we can give her another hand. Does anyone have any questions for her specifically? What is the name of your support group and where is it held?
It's called Sisters of Substance, and it's hybrid. Well, right now it's in person, but it will be hybrid. Sisters of Substance. It's on Facebook. You can search for it on Facebook. There's mentorship and just a lot of resources on that page.
But they also this group mentors families or women that are involved with child protection.
Yes, there is women on there that have experience in that, and there's different varieties of support on there. Yeah, and there's also a chat group you can join for further support, like daily. If you're having a hard time, you can just reach out, and there's plenty of women on there that give out that support or guidance, whatever you need, or either even sit down and say a prayer for you with you. It's really a good support system right there. You're welcome.
Is there a way for women to get involved with that? And honestly, if they want to, they don't really want to be out there quite yet, they want to get that support, check it out.
Yes, just search the page on Facebook, or just search that, message it, and then we'll get back to you on that fast.
Any other questions? All right. I'm sorry to ask. Can someone move? Oh, sorry.
For your support group, is it just people that are involved in child protection or have been involved in child protection, or is it?
No, it's not just specific child protection. It is anything chemical dependency, just whatever support you would need there in place, there is definitely someone in that support group that has that experience to offer you. Yeah, you're welcome.
We have lots and lots of questions, so I'm doing a little bit of combining here because some are very similar. So I might ask a specific ones of specific folks from our panel because they may have been directed towards one person, or maybe because I know, Ben is here as an attorney, and so it might be a legal question, so I might ask one of them. Certainly feel free, any of those of you in the room that wrote down a question, if you don't feel like it got fully answered, all of us are going to be here afterwards. We can follow up. There's going to be information after the presentation that includes like how to contact each of our agencies and tribes. And so by doing that, you'll be able to submit further questions. If there's something that doesn't get answered, we want to try to help you get the answer. We just might run out of time. So sometimes we're limited by that. So this maybe would be a question for Ben, but anyone else can feel free to answer. I just know that there's a law piece of this. So the question is, can a termination of parental rights ever be reversed? Or can a family ever have their children back in their care if they had a TPR?
So I'm going to preface this by saying I don't know a lot about TPRs, and part of the reason I don't know a lot about it is because we don't do this in tribal court, and we pretty much never go along with this in state district court. But as far as undoing it, I think that's a no. Okay, well, you know more than I do apparently, so that shows what I know. I'm just going this down the line and
Not a lawyer,
not
a lawyer. But there is a new statute that in Minnesota that if a child has not, quote, found permanency, right, which the language is problematic, right? They had permanency with their family, but the language is if a child has not found permanency after a number of years, the parent can petition to have the TPR reversed and gain custody of their child back. But only if that child has not been adopted. Yeah. You can vacate an adoption, right?
They can or appeal.
Yeah.
Yeah. So there's, other ways that if your case termination has just occurred, there's a process for appeal. And your attorney should be able to explain some of that to you. Also, when you receive documents from court, a lot of times they say those things and the timelines on them. Yes, go ahead.
So say there's a case where the mother was notified about, she was the only parent notified. Say the father was never notified for child protection and they adopted the children up. What's the father's
recourse? So there's an attorney here, Jill Ash. Do you want to come up to the mic? No, okay, she doesn't want to come to the mic. Who's our ombuds person for American Indian families, but as an attorney, she's saying that, that there would be a motion to invalidate that could be filed. Basically saying, I'm just paraphrasing here, I think, but that the father wasn't given the opportunity to be involved in the case. And so then he would have some standing, I believe, to say that this isn't a valid termination that occurred. So that one of the best things that you can do is there are legal clinics. You can always contact, the Indian Child Welfare Law Center, even though they might not take that case. I know that Andrea and other folks that are there, often answer just some basic legal questions for people or try to point them into the direction to get an attorney in their area. There are different law offices, up north. There's a Mille,
yeah, we have Mille Band Legal aid.
Yep, there's legal aid, there's a number of different things, so I would just say to wherever that person lives, to look at what resources might be by them, and like actually see if they can go have a consultation or something with an attorney. Sometimes there's free clinics, so always try to look for that, just to ask some questions. Okay, go ahead, yes.
So with that being said, when the child is involved with ICWA, and we're talking about, anyways, the outside, it's like mom or dad have the right to appeal the decision, like the grandparents or the aunties or the uncles, anybody who is related to that child, if like, kind of what Caesar was saying, you know, where you said, what did you say that was? Yeah. Motion to, yeah, so
No, I don't.
other family members have the option to appeal that, to file for that. No.
They do not.
But don't we have grandparents rights in Minnesota? What does that mean?
So I think they wouldn't have standing to challenge the, yeah.
Okay.
So no,
Would they be able to, apply for the motion to invalidate if the children were enrolled?
the grandparents or who?
Yeah, like the grandparents on, what if
So-
the child was enrolled?
So the grandparents, I mean, they should try to come forward and be considered for placement, but if the kids end up elsewhere, again, for the same reason, they're not parties with the standing to do that.
So they would have, the relatives would have to talk to the father, like in that one case you were referring to have the father do it.
His family members can't assert his rights for him.
Kind of backwards, because they're looking at just immediate family and that are native ways of how we live. There's a whole dynamic.
Yeah.
Besides just mom, dad, and children.
Can't parents petition or grandparents petition to be part of the case? I've seen
I think they can be parties to the case and be part of the case, but that's,
Yeah. So I don't know if folks on Zoom can hear, but they're discussing like who can be a party to a case, you know, does that refer to, like, can grandparents intervene, and you know, what's being discussed here is that, you know, other people can request to intervene to be a party, and then that's up to the judge to allow or not allow.
I've seen a case where all the grandparents intervened to be a party and the judge allowed it.
So it can happen. It's just, it's really up to them to do the work for that.
Well, I just mentioned not every case.
No, not every case are the grandparents allowed. Yeah. Go ahead.
I was just gonna ask, so it's my understanding the rules of, Minnesota Child Protection Procedure. Grandparents that the child was resided with within 2 years prior to filing, presumptively get to intervene. Anyone else can be permissively, where it says, as long as the court takes the children's best interests.
Okay, so what individual in the room is saying is that in Minnesota, they're stating that if a child lives for 2 years previously to case opening with the grandparent, that the grandparent can intervene. And I think that's just presumptively. Yeah, they shall be able to. So I know in some cases, you know, if grandparents have the children living with them, they might be recognized by the tribe to be an Indian custodian. You know, they might have there might be some other things. So it can be different if a child has shown, you know, that they've lived with that person, or maybe are there with. Yeah, those things can there's a lot of things that can kind of get into the weeds, and it really sometimes depends on specifics of the case, how that plays out. We do have another question here, and that is, someone had asked, are there enough licensed homes to place Indian children in? And if not, what can be done to increase the number of licensed homes? Anybody want to answer that?
I suppose I would say that placement is overused, right? So I think that the first step would be to reduce placement in general. I think a lot of kids who are in placement taking up space in licensed homes don't actually need to be in placement, that with the right safety planning and the supports given, they could be with their parents, right? So if you look at the funding that's connected to out-of-home placement for kids versus connected to prevention, it's absolutely backwards, right? So like systemically speaking, it's kind of more of an upstream issue, right? Like if we could take this funding and say, if you want to have your kid home with you, here's the money you need, the resources you need, the support you need. And instead of giving that to someone else, a stranger to care for your kid, or even a relative, right? You know, we're going to give it to you. So I think that's the first caveat. And then the second piece is most homes that we work with in ICWA are relatives who get licensed for the express purpose of caring for their relative children. And so a lot of times those family members are pretty tapped out, right? So it's not like there are these magical ICWA homes out there that are like tribal members, right? Who like are open to any and all tribal kids. Like that's kind of a unicorn home because most of the time it's really already tapped out family members who are getting licensed. So I don't know, would you guys say more about that?
Did anybody want to say more?
I'm thinking about that.
Send it over to
So just, just following up what Teresa is talking about, no, there aren't enough ICWA homes. Just speaking from lived experience, it was my experience that the county was quick to throw dollars at me to take in my grandson. It wasn't about the money, it was about the fact of helping, my family. And I wasn't the first option. You know what? It was to go to the custodial parent and their extended family. They were just up there in age and they couldn't take, my baby. And so I was second choice. But when it wasn't even Hennepin or Ramsey County, it was a different county. But they were just got me licensed so fast to be a foster parent, and if it wasn't our home where my baby was going to remain, I'm not quite sure where he would have gone. So, but after placement, continued funding, and then it was as soon as a little bit further down the line, the funding stopped. But I think for me, it was really just about, throwing dollars at me to take in my family. And granted that, yes, it is helpful. However, that was not the reason why my baby was with me. And it was about a case plan that both custodial and non-custodial parents needed to work on, but didn't do that. And when that piece, when both parents weren't working their case plan to reunify with their child, it moved really quickly to being a placement option, kind of a forever home. And grateful, but I was asked about continuing to be a foster parent. I personally wasn't ready to And I didn't have the home capacity to do that, but it was about, I just felt like it was about money. And so I chose not to continue to be a foster parent at that time. And so looking back, I mean, not for any monetary reason, but having a deeper understanding of ICWA, I would have continued my license. So thank you.
I'll read it. Okay. So I'll read a question from the audience for Red Lake. Family preservation is so important. So why would ICWA ever deny a tribal member their support if a parent was enrolled but the children were not? Speaking from lived experience. And so I think that comes down to the tribe's designation of what cases they intervene in. So prior to 2019, Red Lake only intervened prior to fall of 2019. Red Lake only intervened if the children were eligible to enroll. So in a lot of Red Lake cases, and I'm so sorry for this, for whoever asked this question, but at that time, the designation for what we involve ourselves in was if the parent, if the child was eligible. So we had a lot of enrolled members who were just at that blood quantum cutoff, 1/4 Red Lake blood only, right? And then their kids were not eligible for enrollment, and that was what ICWA went off of. In 2019, we started tracking how many kids were being lost to non-ICWA cases, and we presented that to tribal council. We said, we got a spreadsheet, and we said, hey, look, this is how many kids of enrolled members are going non-ICWA who are experiencing TPRs, who are put in non-native homes. And we had support at every level of our agency to advocate, and that's when we came up with the descendancy resolution. I know we're not the only tribe that does descendancy, I don't think. But then later that year, also in 2019, big year for Red Lake Nation, they changed their blood quantum. So they made everybody who was on the 1958 rolls, right? 4/4, right? Again, we're speaking in really problematic language, but that is the language that it is, right? They made all those people 4/4. So then everybody's blood quantum changed, and then that means even more children were eligible for ICWA. So that may be why, like, maybe in the past you're like, I've never seen a Red Lake case, and now it's like there's so many Red Lake cases because of a number of things happened in 2019. So I apologize if that was your experience.
Yeah. Sorry, I just have a question just in the middle of answering a question, but okay, so what you said in 2019?
Correct.
Okay, so what is Red Lake ICWA's involvement now to all those cases prior to the descendancy?
Great question. We went back and yep.
What's going to be done?
Yep, we went back and found those cases, and if they were still open, we intervened. So that our caseloads went from like tripled, right? Which is amazing. But that's why we also went from like one worker in the urban office, who was myself, and to 6 or 7 ICWA workers, because we had to respond to capacity. So we did go back and find those cases. We didn't intervene in the ones that we still could. That being said, we are finding a lot of cases where families are like, I experienced an adoption, or I experienced this. And like Laura was talking about, we'll try to send those. We never want to turn a family away. So we'll always try to find the right resource to point that family to. Yeah. But we did go back and find those cases if they were still open. Yeah. It's a lot of work, but it's worth it.
Yes.
Yeah. And then if a parent completes their case with child protection, why do they show up and take a newborn from birth without an open case? That's a great question. I think it's tiny soapbox, one of Minnesota's cruelest policies, and I'm just going to say that for what it is, but it's called birth match. And so essentially, if you've had a termination of parental rights, you've been deemed palpably unfit, right? That is the terminology, palpably unfit to parent. So when you have a new baby that is screened in, and you have to be, quote, reassessed in an open child protection case, the statute says that counties can file an expedited permanency petition and just file to immediate, like basically, you one time and you're screwed, right? And that is It's not okay. It's not acceptable, right? And even now, if families have experienced this involuntary transfers of custody, counties will still try to file those EPPs, expedited permanency petitions. So I think it's, if there's, for tribal workers in the room, we have to push back about those. Your second case could have been an EPP, could have been expedited permanency. St. Louis called me and asked me to do that. And we were like, absolutely not, right? Like tribes need to know that like, you can push back on those EPPs, right? And we fight with some counties all the time about this, that the reason for not filing an EPP, expedited permanency petition, is the tribe's preference can be considered good cause, right? And so like a certain county that we work with, we've gone round and round and round, but now their supervisor, their attorney has come to us and said, we're going to go with this. We're going to say that if Red Lake says we don't file a permanency petition right off the bat, that's good cause. That's our practice now. That's huge, right? That's huge systems change. But it's in Minnesota child welfare statute. The birth match is an automatic screen-in. It needs to be changed. Yeah. I've reunified parents with like 8 TPRs.
So I would just say to families that, have experienced that or know someone that's experienced that or that is pregnant and they know that they've had the past child protection, to not be afraid to reach out to folks that would be advocates for you. So, contact the Minneapolis American Indian Center, contact your tribe ahead of time, contact, MIWRC or DIW or what's the organization in Duluth that has what? Indian Legal. There's lots of places, but anywhere you would go for services, go and talk to those folks and let them know what your situation is, because Minnesota is trying to do a better job, like the counties, and they're supposed to all be looking at the situation because it's been so detrimental for our families. And so, if the sooner people know, and that might be something that you struggle with, then you can have someone in your corner and, kind of be helping you and guiding you. There's the tribes have lots of programs. DIW has some programming. The Indian Center has a program called Bright Beginnings. We work with moms that might have had this issue and are kind of there right from the beginning. So hopefully by the time we get to court, there's a lot to be said about what the mom's been doing and can kind of fight against some of those things. So, hopefully that won't happen as much as it has in the past, but, that's something that lots of people are trying to work on. So I would just say, reach out right away. Don't automatically think like, oh, it's just over. I'm not going to even get to do this, because you absolutely should be able to parent. And you just, you might just need some extra help and someone to advocate for you, because unfortunately there's that law that exists.
And then the mom should be sure to tell the father about their termination of parental rights.
Yes, that's an important thing. Yeah. Moms should tell the fathers of their children if they had something like that happen in their past, because all the much more prepared the dad or the dad's family can be if you wind up in a situation like that. There was a question here about kind of more specific to Wisconsin. What's the best way to advocate for ICWA before graduating law school? So yeah, there's lots of stuff to ICWA. That's why we do these meetings, because yeah, it's so complicated, right? And what advice would you give on trying to educate rural Wisconsin about ICWA?
Someone is in law school. Is it you in the white? No, that was according to statute.
She's an attorney, but it's the
Oh,
the
okay.
other
Oh,
one
so
at the
you've
table with her.
been there, done that. Okay. What is the best way to advocate for ICWA before graduating law school? I would say that any kind of work that you can do with ICWA or around ICWA would be a form of advocating for ICWA. If you feel so inclined, if you're on law review, I suppose you could write a law review article about ICWA and get that out in circulation. Advice on educating rural Wisconsin about ICWA.
We need to have legislation to have an ombudsperson for American Indian families.
Okay, they need a.
With
Okay.
Okay.
So
So-
Jill is saying that Wisconsin doesn't have what Minnesota does, which is an ombudsperson for American Indian families. So she's throwing that out as a suggestion.
Sure. And then I'm just kind of thinking out loud here. I mean, I guess you could write a letter to the editor or something about what this is and why it's beneficial and why you should be paying attention to it. And, yeah, I like,
Could you really educate your judges to do additional education?
that's very good. You could try to organize some kind of, I guess, judicial conference or
Judges need education.
talk to local county bar associations so that they know about it, and they know why it's important, so that people that are county attorneys in rural Wisconsin counties, maybe they don't see a lot of ICWA cases, and maybe they don't know what it is as much, or they need to know about it as well. Yeah, absolutely. Anybody, reach out to other organizations that give education on this and try to get them out there.
Okay, so this is a question actually for Andrea Sanders, if you can chime in on this. Does the ICWA Law Center only help families with previous transfer of legal custodies if they worked on the case with them? Or will you take on a family that needs support with this that maybe you didn't work with in the past? That's
Hi. Yeah, it depends on the situation, and honestly, it would entail calling in and doing an intake, and I'm normally the one that does the intakes. But if it's a situation where there was a transfer of legal custody to whomever, and they're in agreement that the child or children should go back with the mother, then that certainly is something that we can look at. It obviously has to be in the state of Minnesota. One of sort of the main criteria is the fact that it can't be contentious, because that those get very complicated, and it's a very high threshold to transfer back if it's contentious. You have to show that there's some imminent harm or danger currently with the child or children. You also have to show the significant changes that the mother has made on her own. So you basically have to prove that the other person is unfit to parent. So that's why we don't do them if there's, if they're not in agreement, but certainly if they are in agreement, then that would be something that they could call and do an intake with us, and certainly see if it's something that we could help with.
But also like thinking kind of upstream, right? Again, like systemic change and solutions. As a family in the system, you can ask, hey, I know I'm going to do this transfer of custody. I am going to consent to this transfer of custody, but I would like this petition written with the family court best interest standard, and then talk to your tribal worker and say, can you please advocate for the best interest standard in this petition? And then when you want to come back and maybe look at the transfer of custody again, that endangerment standard that Andrea spoke about is not an issue. It would then be the family court best interest factors about the reversal. So at Red Lake, we ask, almost all of our permanency petitions are written like that.
We are just about out of time for the night. I think we can do this one last question, but it is a big one. And I don't know, I guess I'm not sure who could answer it, but have you heard about the Supreme Court getting rid of ICWA? And what do you know about this, and is it true? So yes, there is a court that, there is a case that is in front of the Supreme Court. So that is true. It has not been decided yet. Does anyone have, what's that? Yep, they'll start hearing it in October. And I think probably the best resource to just like find out a little bit more about it would be to go to the National Indian Child Welfare Association website. They talk a lot about that. They talk a lot about how to advocate for ICWA. And I think maybe the only other piece to add is that one thing that is great about Minnesota is we do have a Minnesota ICWA law. So I know there's folks working on strengthening that and, you know, kind of doing some work with that, but we do have a law here just in Minnesota. So whether or not there was a national law in Minnesota, there is a Minnesota state law. I think that's all the questions we have time for tonight. Those of you that are in the room, you can still ask some things once we finish the Zoom. If you have a question of anyone individually.
Everybody should listen to This Land podcast season 2, and it is about that, about ICWA, but really it is more about attacking sovereignty, and that really gets into it. That's such a good resource.
Okay. This Land podcast is being presented as a good resource to check out season 2 as a good thing to help you learn about all of what's happening surrounding this challenges with ICWA, the ICWA law.
There's also a website called Turtle Talk, which is curated by Matthew Fletcher. He literally wrote the book on federal Indian law, and among the different cases that he's tracking is this Supreme Court case, and you can. He always has all of the motions and briefs and everything that you can follow along with if you feel so inclined.
Can you repeat that?
Yeah, so it's
Turtle
called, it's turtletalk. I don't know if it's .com or .org, but if you Google that, you'll find this attorney's website, and it just tracks all the filings, and he gives his 2 cents.
I think that is all we have time for this evening. I want to give a special thank you to all of our panel, to our Minnesota Urban Indian Directors Family Preservation Subcommittee, and to everybody that's here in the audience tonight. I know it's a little different to do hybrid, but we want to be able to record these because just as hopefully you learned some things tonight, but we want lots of families to learn. You know, if you have a friend or relative that you think this would help, it's going to be available recorded. They can, you know, they can listen to it from their home too. So thanks everybody and have a great night.